City, where just hours ago a judge delayed the sentencing in former President Donald Trump's hush money trial. His sentencing was set for next Thursday. Now it's going to be in September, and there's also a possibility that his conviction would be thrown out. Joining us now to discuss it, Chief Legal Analyst Khalif Rhodes. And Khalif, this is connected to yesterday's immunity ruling from the Supreme Court.
Well, 100%. I mean, if you had July 11th locked in on your calendar, you can forget that now. It's now moved to a new date, rightfully so. I mean, within that language, Justice Roberts said that the president in certain things has absolute immunity, and in certain situations, if they are doing official acts, has some immunity, and then there is a presumption of immunity. And so because you have all of this types of immunity, you got to go back and look at this case and figure out, well, should he be convicted? His team, hours instantly after that came out, they went and filed their motion to have that set aside. The DA's office decided that they won't intervene and allow the judge to make a decision. And there's a couple key factors when you look at this. Specifically, the Supreme Court said not only can you not charge a person criminally for official acts, you can't even use that as information for things that were unofficial acts. So if you look at this case specifically, the Hope Hicks phone calls and other information while he was within his office, when they used that during that trial, there were a number of conversations that happened about the meetings in the Oval Office, receiving mail in the Oval Office. And if they are saying you can't even use that as evidence in the prosecution for non-official acts, it could be problematic. And so the motion makes sense. However, there was a lot of evidence in that case that was not official acts. So we'll see.
All right. So for those of us like myself that don't have the legal genius brain that you have, explain that a little bit, because you're saying the Manhattan DA said that they would not oppose the former president's request to have his conviction then tossed. Why is that? Like, well, why would I thought I was a little surprised with that?
Well, they're not saying that they are open to it, the conviction being thrown out. They're saying they're open to them entering a motion and having a hearing so that the judge can make a determination. Okay. Two separate things. Okay. Because in their answer and their response to their motion, they said, listen, we think their motion is baseless. We think that the merits will still stand. We believe a jury of his peers convicted him, and we believe once you review all the evidence that was presented before the court, that you will find that even if you remove the evidence that had acts that were official acts, that he still would have been convicted with the unofficial acts. That would be their argument. That's what they mentioned earlier. Not that they're saying that the conviction should be set aside. Not at all. They're saying he should have a hearing. We're open to it because we believe that we're clean in this case.
Let's go back to the evidence part here, because that's the tricky part of this whole thing, because a judge already prior ruled on evidence that were not official acts as president when he tried to pay off a porn star.
100%. I mean, what I can tell you is if I'm the criminal defense attorney representing Trump, I'm doing the exact same thing, because I don't think you can see past that. While I agree that the judge removed official acts and unofficial acts and did an excellent job of attempting to go through those weeds, we're in new territory now. The Supreme Court has ruled that official acts cannot be used, but unofficial acts cannot be used. And you can't use those official acts as evidence against. I think there were a number of times that the prosecutors used official acts to kind of lay the foundation for their case. And because they did that, if I'm right with them, I'm asking for that case to be thrown out and do it all over again. I think it still gets to the same result, which is a conviction, because there were enough unofficial acts in that hush money case.
Which is what the judge said.
Right. You didn't need the Hope Hicks conversation. You didn't need the things that happened in the White House. You needed checks, you needed payment, you needed hiding of it. That's all you needed. And you would have still got a conviction.
And we started this conversation with the word delay. I think that's one of the things that you're constantly hearing. Just to remind everybody, the Republican National Convention is July 15th through the 18th. I want to just get your take on how this plays in with all that, because I think originally when we were covering this, that was the date of the July 11th that would have run before this convention. Now that's not going to happen.
We can take it all the way back to when he originally was indicted. If you think about it, we were saying, wow, this is going to have implications into the election and him getting the nomination. Yeah. And his legal team, you got to tip your hat to them. They've done an excellent job doing all he needed them to do. Push it down, push it down, push it down. Now this pushes it further down the road than any of us could have imagined. I mean, you're talking about no trial at all happening this year, and likely not happening even next year, because all those appeals will continue. Even if Judge Chuckin in D.C. decides that, you know what, these are official acts, they'll immediately appeal. And then once it goes to the Court of Appeal, they'll take it to the Supreme Court. So yeah, he has time on his hands right now. And again, tip my hat to his legal team.
Khalif Rhodes, appreciate your insight.